Good morning, everyone. Thank you for joining us today for our Returning to the Workplace webinar in partnership with DMH Stallard. For those who don't know me, my name is Chloe Morris and I work alongside Louise Sorrell and Sarah Robinson at Badenoch and Clark, where we specialise in recruiting the best HR talent across the South East. We'd all love to hear your thoughts and feedback following the webinar today and stay in touch regarding future events. So please do reach out to us afterwards if we can help with anything. Today, Louise, Sarah and I are really happy to be back in the office and working together again and having just a little bit of normality. However, as we ease gradually back into normal life, not everybody is going to feel like this. Some people will, might feel stressed and anxious, and some people may refuse to return to the workplace. There are lots of important factors to consider as companies begin to return to go back to the workplace and a little bit of normality. So with this in mind, we've teamed up with our local law experts, DMH Stallard. So I'm going to hand you over to Abby to talk you through the webinar. So I'll hand over to you now, Abby. Thank you very much.
Thank you, Chloe. Good morning, everyone. Yes, I'm joined by my colleague, Adam Williams, and we'll be having a look at some of the issues about returning to workplace and balancing your business requirements with perhaps changing staff requirements or requests in the new working world. It's a huge topic and there's no way we can cover absolutely everything in an hour, but we're hoping to look at some of the themes that we've seen crop up quite a bit in our own practices in the recent months. So as you all know, it's Mental Health Awareness Week, so we will be looking at mental well-being through a legal lens largely, some of issues around stress and anxiety, a recap on health and safety obligations in terms of getting people back into the workplace. Adam will look at some vaccination and testing considerations, whether you can make that mandatory and whether you would want to, and some of the issues if you do. And then we'll pull things together at the end with a scenario which will look at some employees who might refuse to return to work for various reasons and what options there are for you as employers. And if we have time, we will answer some of your questions. So if you do have any questions as we go through, please use the Q&A function at the bottom of your screen, and we will do our best to answer those at the end if we have time. If we don't have time, we will circulate the answers after the event, so we will get to your questions at some point. If there are any technical issues as we go through, then if you use the chat function, then one of the team will be able to pick that up. So we'll start off by looking at some of the legal considerations with mental well-being in the context of returning to work. And I wanted to start off by asking you in the audience whether you have any form of well-being strategy or you've got plans to introduce one in the workplace. Now, well-being has lots of different meanings for different people, but principally, according to the CIPD, it's promoting a state of contentment which allows employees to flourish and achieve their potential for the benefit of both themselves and the organisation. And it can be looking at various things such as mental health, but also financial health, physical health. So various different ways in which you can promote a strategy internally. So we'll just wait for the results there. "65% of you do have a form of wellbeing strategy, which is great, because actually a recent survey polling a number of organisations found that only 44% on average did have a wellbeing strategy, and only 9% actively measures that return on investment. So it seems like the audience is well ahead of the trend there in terms of a wellbeing strategy. And why it matters, moving on, as I said, it's not just about mental health, but we will have a focus on that this morning. A Deloitte analysis at the beginning of 2020, so before the pandemic actually hit, updating research they did in 2017, which fed into the Stevenson Farmer review commissioned by the government into mental health in the workplace, showed that poor mental health has actually risen 16% since 2016, so since their original analysis. And the cost to UK employers is £45 billion each year. So very significant. And on average, they found that for £1 spent on mental health support in the workplace, employers got back £5 on their investment. And that was through things like perhaps reduced presenteeism, absenteeism, and reducing staff turnover, which might have been affected by mental health issues. And one of the statistics that I found really surprising is it's estimated that 75% of people with a diagnosable mental health issue receive no treatment. So there might be a number of people within your workplace that are suffering and not getting the support that they may need. And 1 in 4 people will suffer from mental ill health every year. So it is highly likely that within your own workplace there will be a number of employees who are suffering from mental ill health each year. And in terms of the pandemic, the Chartered Management Institute estimated that 62% of managers believe that a return to the office will have an impact on employee well-being. And CIPD found that 80% of organisations were concerned about the impact of COVID-19 on employees' mental health. So it is much more at the forefront at the moment in terms of thinking about return to work. And dealing with mental health issues can be difficult for managers and organisations because, you know, for a number of reasons, it can affect anyone. It's largely invisible. It can arise outside of work but be exacerbated by work, and it can be difficult to diagnose. And all of these things combine to create sometimes quite complex employee relations issues. And turning to some of the legal considerations with management of employee wellbeing and mental health, well, there's a common law duty of care for employers to promote a safe system of work, so to ensure that risks to mental ill health are minimised insofar as is possible. And if the actions or inactions of an employer injure an employee, cause any mental injury or ill health, and that's reasonably foreseeable, then that could give rise to a personal injury claim against the employer. There's also Equality Act considerations. So the definition of disability encompasses mental impairments, and put the definition up on the slide there. So a person will be deemed to be disabled if they have a physical or mental impairment which has a substantial and long-term adverse effect on their ability to carry out day-to-day activities. And for most disability claims, knowledge by the employer is needed. Not all claims, but a lot of claims, knowledge is required of the disability. But an employer is obliged to do all they reasonably can to discover whether that person, worker, has a disability. So it's not enough for an employer to turn a blind eye if there are signs that there might be some mental ill health and that could give rise to a disability. Then an employer does have an obligation to do what's reasonable in terms of investigation. So that might be things like occupational health. The health and safety executive management standards aren't compulsory, but a good practice, and they look at things like addressing the demands of a role, so what your workload, work pattern and environment is like, the control that an individual has in the way that they work, the support that they receive from colleagues and line managers, promoting positive relationships in the workplace and dealing with unacceptable behaviour, ensuring that individuals understanding their role within the organisation, and how organisational change is managed and communicated. So those management standards are, as I said, not compulsory, good practice, and feed into a culture of well-being. If employers don't address certain concerns, then that could give rise to grievances. At an extreme, claims for constructive unfair dismissal if employees feel that their the implied duty of trust and confidence has been breached by the employer. And if mental ill health or stress or anxiety causes them to be off work, then employers will need to look at absence management and potentially dismissal if that's appropriate. And obviously any dismissal potentially gives rise to claims for unfair dismissal if that individual has over 2 years service. So there are some legal considerations to navigate in these situations. And of course, data protection in terms of the management of information you receive about an employee's mental health. That would be special category data and processing of that type of data in limited circumstances. So you'd be looking at things like the consent of the employee, or if it's necessary to process for carrying out rights and obligations under employment law, such as health and safety obligations. But care needs to be taken in terms of how you use special category data. And Adam will touch on that again a little bit later in terms of vaccination and collecting data in that respect. In terms of concerns when returning to work, we've had a lot of employers calling us saying that employees are feeling quite anxious about a return to work. And I've put a definition there from the Mind website about anxiety, and that says when we're worried, tense or afraid, particularly about things that are about to happen or that we think could happen in the future. And you can see that the pandemic and the significant uncertainty that surrounded that has affected a lot of individuals in terms of that feeling of anxiety. There's been a lot that's been out of our control. There's been a lot that's changed rapidly. And a return to work, although it in one sense seems like a bit of normality, it's actually quite a big shift from what's been happening in the last 14 months or so. So some of the concerns that have been raised are around health. So, you know, how likely employees might be to contract COVID if they return to the workplace. Now, the balance of that, I think, has been shifting as vaccinations are more widespread, transmission rates start to come down, but nevertheless there is an uncertainty, I think, about how the opening up is going to affect transmission rates. Change anxiety, I think that's probably one of the most significant ones that we come across in terms of employers and our clients calling us. The whole scale potential change to their routine and ways of working, organising childcare where they might have had to change those arrangements over the past year. You know, things like dog walking, you know, they might have had a dog walker 14 months ago, they haven't got one anymore. So concerns about leaving loved ones, pets, all of that feeds into the concerns about returning to work. Social anxiety, so not having been physically around colleagues for a significant period of time and worrying about how that interaction will be when they go back. And some individuals are returning from furlough or have recently returned from furlough, and they can experience some sort of anxiety in terms of connection back with their employer and with their colleagues, having had what might be a significant period of time off. And all of that can impact on focus, motivation and productivity at work. So it's important for employers to invest some time in trying to deal with this so that they get the best out of their employees. In terms of spotting signs of mental illness, potential mental health issues, put up there some helpful bullet points from the ACAS guide in respect of mental health in the workplace. And it's a non-exhaustive list, clearly, but some common themes in terms of changes in employees which may signal that something's going on. So appearing tired or withdrawn or worried, an increase in sickness absence or potentially being late to work or to log on, changes to standards of work or focus, being less interested, and any general change in mood or behaviour towards colleagues. It is harder to spot these signs when people are working from home. So that's why many employers are having regular check-ins with their staff, whether that's face-to-face via Teams or Zoom, or on the telephone, or through a variety of different methods, just to see how they're doing at home. And be aware if you do have or spot some signs of a mental health problem now, it may not be a new problem to that individual. It might be new to you as an employer, and it may be have been exacerbated by the current situation, but it might not have been new to the individual. So it's always sensible to explore whether there is a longer term underlying problem, or indeed this current problem may be a long-term problem, because of course that feeds into the definition of disability under the Equality Act, and then influences what your obligations are as an employer in terms of reasonable adjustments, and so on. So in terms of helping the transition back to work, I've just put up there some things that can help with that. The first, in terms of planning, is to look at your risk assessments and your consultation, and we'll come on to that in the next section in a bit more detail. In terms of making employees comfortable and reducing that anxiety, communication is really important, and that is best from a variety of sources. So it could be from HR, from line managers, having surveys and forums, so allowing employees to input into the way that they return to workplace, making them feel that they have a little bit more control and ownership over the process, can help with their feelings of stress and anxiety in terms of this change. And mental health support in the workplace. So there are wellness action plans that you can get from the Mind website. They're free to download in terms of supporting employees back to the workplace. Many employers have mental health first aiders that can talk with employees about any concerns that they might have. Employee assistance programs can be really useful, and making employees aware that they're there and that they are confidential and a resource for them to use if they are feeling concerned. And if employees really are very concerned, then occupational health is there to understand the nature of those concerns and whether there's anything that the employer can do to alleviate or assist with that. So moving on, I wanted to do a brief recap on health and safety. I know it's been talked about a lot in the last year, but I think it's important just to come back to it in terms of putting things in place for return to work, and also in terms of the context of how reasonable or otherwise it might be for employees to say that they don't want to come back. So as a brief overview, there are certain key areas from which health and safety obligations cross into employment law. So there's a common law duty on an employer to provide a safe system of work, and also an implied term of an employment contract that an employer will take reasonable care of the health and safety of their employees. Secondly, there's statutory obligations to provide safe systems of work. So there's the Health and Safety at Work Act 1974, which imposes a general duty on employers to ensure, as far as reasonably practicable, the health, safety and welfare of their employees. And that's important for employers to adhere to, because it is actually an offence not to comply, and it can result in individual directors being subject to criminal sanctions or disqualification. So the stakes can be quite high if it's not complied with. And it's important to remember, in terms of those statutory obligations, that the duty to ensure health and safety of employees is a non-delegable duty. It's the obligation is on the employer to make those decisions. So you might have a number of employees, and you might have had over the past year, who want to return to work or are willing to work in circumstances where there might not be sufficient social distancing, or it might be not in line with the government guidance. And it's not for those employees to assume that risk if they want to, and that be fine for the employer. It's for the employer to say what they believe is a safe system of work, and for the employee to follow that. And that can be difficult, where you've got employees who are desperate to come back for one reason or another, or that they want to do things in a slightly different way because they might not see the point of some of the rules that you're putting in place in terms of making the workplace safe to return. And thirdly, there's government guidance to take into consideration. So the government has produced a number of different guides in terms of making workplaces COVID secure, depending on the type of workplace. And so they all need to be referred to and followed as part of your risk assessment process. In terms of the employment law aspects of those health and safety obligations, generally speaking, employees need to obey reasonable management instructions. So if you ask them to come back to work, then it's on the face of it a reasonable management instruction. However, there are sections of the Employment Rights Act that prevent any detriment or dismissal if an employee raises health and safety concerns. Now, those health and safety concerns have to be in circumstances where they reasonably believe that they are in imminent and serious danger if they either stay in work or refuse to return to work. So there are a couple of points in that. The first one is the concept of whether there are circumstances of danger. Now, clearly, over the past year, a global pandemic is circumstances, or would be deemed to be circumstances of danger. But that all needs to be in the context of things like transmission rates and chances of serious illness through things. And as we move on, and hopefully we will continue on the path that we're on, circumstances of danger posed by COVID-19 are being reduced all the time. So whether it's an employee has a genuine belief in that that COVID-19 presents circumstances of danger to them, potentially will change as time goes on. Now, it could go back the other way if we get new variants. It's a fluid situation. It could also include the risk of contracting COVID-19 from infected colleagues. But as the vaccination uptake increases, then, and hopefully there's a reduction in cases continuing, then the risk and the circumstances of danger posed by that also reduces. And then the second point in terms of that protection under the Employment Rights Act is whether the employee reasonably believes they're in serious and imminent danger. And that involves looking at a variety of factors, including things like what COVID secure processes you have in the workplace, what the transmission rate is like, what sort of variants we have at the moment. And there's been a couple of first instance cases in the tribunal looking at this, none of which I think we can with any certainty take any general principles from, because they're all very fact specific. But for example, there was a case, Rogers and Leeds laser cutting, which took place, the the actual event took place in March last year, so right at the beginning of the pandemic. The decision from the tribunal wasn't until quite recently this year, but in that case, there had been a positive test in the workplace. It was a factory workplace, quite a large area, social distancing in place. There was a positive case. The individual went home to self-isolate. Mr. Rogers said he wasn't going to come back to work until the pandemic had eased, because he was concerned about his passing the virus on to his children, one of which had an underlying health condition. Now, as part of that, he had less than 2 years service and ultimately was dismissed and brought a claim under Section 100 of the Employment Rights Act for the dismissal as a result of raising health and safety concerns. Now, what happened in that case is that the tribunal looked at what the relevant government guidance was at the time, which was, to wash hands and to maintain social distance. Remember, this was right at the start of the pandemic, which the employer had implemented, and the fact that Mr. Rogers didn't articulate why going to work put him at a particular danger, as opposed to all of the other things he did in his life. And he drove someone to hospital the day after that he said he wasn't going to come to work, and so the rest of his actions weren't consistent with thinking that there was a particular danger with going to work. But it was very fact specific, but it does demonstrate what tribunals will look at in terms of a reasonable belief. And clearly doing your risk assessments and communicating with those within employees will help in terms of the return to the workplace and dealing with individuals who say that they are concerned and don't want to come back. Every case will need to be looked at on its own merits and in terms of the individual raising the concerns. But those two factors, circumstances of danger and reasonable belief, are really important in terms of assessing that. Just quickly, another potential avenue to look at there is whistleblowing, and just be aware of whistleblowing protection. So if an individual has raised a qualifying disclosure to you and it's protected in relation to any health and safety concerns at work, they have protection from detriment or dismissal as a result of that. And again, no qualifying length of service and uncapped compensation potentially. So in terms of a return to the workplace, when planning that return, it's really important to follow that government guidance, undertake your risk assessments, consult and engage with staff. And that's not only because of your legal requirements to do so with unions or elected reps or employees directly, but also in respect of managing that stress and anxiety that they might feel. Share the risk assessment, and most importantly, implement the risk assessment so that you reduce the chances of people making potential protected disclosures for health and safety concerns, or indeed any grievances that they might raise as a result of that. I'll now hand over to Adam to have a look at some of the vaccination issues.
Thank you, Abby. Yes, so we're going to look at vaccinations and testing, everybody, which is definitely an area that is moving and developing, as with many aspects of the work implications of the pandemic. So we're going to look at the current state of play and some developments and trends and things for you to think about in terms of how you approach the issue of vaccination and testing in your workplace. But firstly, a poll question for you. Have you introduced a COVID vaccination or testing policy in your workplace yet? Maybe something you're thinking about introducing, or you've decided that you won't, or you've already introduced one. So have you introduced a policy in your workplace so far? We'll just wait for the results of those to come in. Okay, so overwhelmingly no, just over 80%, which is not a surprise. That's what I would have broadly expected, that most of you haven't. About 10% have, and a few are unsure whether they will or not, or whether they have or not. So most people haven't yet. This is a good opportunity for us to have a look at some of the key issues, decide whether that's something you want to look at doing, and if you were going to introduce some policy themes and rules, what might they look like? What are some of the key issues then? Well, big ones that the press pick up, and obviously you will have seen a lot about in the news and media, is can you impose a mandatory vaccination? The rather inelegant "no jab, no job" slogan that you will have seen. Can we dismiss an employee fairly if they refuse to be vaccinated? Can that be possible? In what circumstances might that be the case? Is it possible that vaccination policies and requirements could be unlawful discrimination? We'll look at that in a bit of detail. The answer is potentially yes. We'll look at how that might arise. There are human rights issues. Very little in the way of case law for precedent on this in the UK. Some European case law will touch on one case dealing with this issue of the human rights to things like private life, family life, and whether requiring vaccinations unlawfully impinge on those, and data protection issues, which is something that Abigail had already talked about in her session. Same sorts of issues we'll touch on around special category data and how you manage those and retain the data. That's one of the important issues on data protection aspects. So there's some of the key issues. This is an area where, as I said, it's fast moving, and it's a challenging area for employers, I think, because the landscape on which you might be choosing and setting your course is subject to change. It's shifting. We've got things like the rollout of the uptake of vaccines. So if you think about that, for example, at the moment, it's physically not possible for every adult in the UK to get a vaccination, even if they want to, based on age. And so that has an influence and a bearing on things like requiring your entire workforce to be vaccinated. Not everybody can do that, depending on age. Legislative developments, we'll touch on that, but at the moment we don't have any legislation that would give legal force behind a requirement to vaccinate or force testing. We've got the new variants issue, where the position in relation to our risk exposure to the virus could change at any given time. There's an uncertainty around the effectiveness of vaccination against new variants, which does permeate across this whole area of the importance of vaccinations and the justification for requiring them, for example. And we've got talk in government about COVID status certifications and changes in the testing availability and regime that have shifted as well. For example, in the last month or so, much greater availability of lateral flow testing twice weekly to anybody, which is a very materially different position to the availability of testing beforehand, and that changes our view on things like the availability of testing, and therefore how much a vaccination is needed. Are they truly necessary in your work context? And a key one here is the link or not between vaccination and reduction in transmission. This is an area where the science is developing. In the last couple of weeks, we've started to get some reports of evidence of there being a link between vaccination and reduction in transmission, something around the 40-something% from memory. But that's a key area here in terms of, as we'll look at, the justification for requiring testing around health and safety and public health. A large part of that will be informed and influenced by the evidence to support it actually reducing the risk of transmission. And so that's going to be a key issue. So we've got lots of variables moving around in the background here. And they're going to mean that we have to keep this under constant review effectively. Let's talk about mandatory vaccinations then. And this is something that there's been a mixed bag of opinion on this within the different constituent groups. So there was some studies by HR Locker in January that said 23% of employers plan to make vaccinations mandatory. Nearly 50% of recruiters had said they would prioritise vaccinated applicants during recruitment, and nearly 60% of managers polled by the Chartered Management Institute in March of 2020, so when it's very early days when the pandemic started, had said back then that mandatory vaccination should be the approach. So there's been some support for the idea, but the position in terms of the guidance and what the government's saying is mixed, we could say. The current ACAS guidance, which you can find on the website, now says that it's best to support staff to get the vaccine without forcing them to. And that was a change in February that was made to that guidance by ACAS, where previously they'd said, in some instances, disciplinary action may be appropriate or even dismissal. Those statements have been removed, no doubt because of, I assume, a sense of the legal difficulties associated with that, potentially, unless you're in fairly unique circumstances as an employer in terms of your reasoning for taking those actions. The Prime Minister gave evidence, though, in late March to a liaison committee saying more boldly that it'd be wholly responsible for care home companies to think of requiring vaccinations. And there's some consultation been launched earlier in April, mid-April, on making vaccinations compulsory for those in older adult care home settings. But we can see that the risk profile and health and safety prerogative there is distinct from many other sectors, and we'll touch on that again in a few minutes' time. There's also, we've got the absence of new laws. That consultation hasn't resulted in legislation yet. And so there aren't any laws that require an employee to be vaccinated, or entitle an employer to require it, which means it would be an offence if you forced or subjected your employee to vaccination through force. It would be an assault, effectively. So we can't physically force it, and this issue really becomes more about, can we make it conditional, make it a condition of something else, like a job altogether, or indeed a certain aspect of a role where there's an opportunity for the individual to earn more money, for example. Can we say, well, you're no longer allowed to do that or able to do that unless you've been vaccinated? And a key point we'll take forward as we look through the issues is that the workplace setting and the associated health and safety risks to workers, or indeed customers or service users, is likely to be a key factor here when you're thinking about how confidently you could require vaccination as a condition of employment or other aspects. So yeah, requiring vaccinations, well, this is untested in Great Britain, even by the government. The government's position is not tested on this, not something that we've done previously. And so that's the complication. We don't have a backdrop of law to say, well, there's this case law that says it was appropriate to require it in these circumstances and not in this. It's new territory, and that creates a risk that employers could become an initial test case, win or lose, around the requirement for vaccinations, and typically not something that employers are going to want to be, given the risk that you might lose the case and the negative press around that. Another important issue is that vaccination is not suitable for everyone. If you've got immunodeficiency health issues, you've had long COVID, pregnancy is another complicated area, it's not suitable for everyone. So a blanket approach to requiring vaccinations from everyone wouldn't be suitable in the vast majority, if not all cases. It could be indirectly discriminatory. We touched on the issue of requiring everybody now to be vaccinated, where you can see how, based on age, if you're under 40, anyone under 40, and you haven't happened to have a vaccination through being clinically vulnerable, you won't be able to meet that blanket requirement. It isn't a requirement that directly is based upon age. Everybody's expected to meet it, but you as an under 40-year-old can't. And that means there's a case to argue it's unlawful indirect age discrimination. Now, that can be objectively justified by an employer, potentially, as long as they can show that they have a legitimate aim. Here, that would most obviously, or usually, I think, be health and safety, protection of health and safety of the individual or their colleagues, co-workers, service users, customers. So you have your aim, but a critical part of this is that the means you use to achieve it must be proportionate to the aim. And so not more than is necessary, and creating a harsher impact on the affected group, i.e. younger people in this case, than is proportionate. That is a key issue, a highly fact-sensitive one, and it's where the issue of the level of need and justification for requiring vaccinations in the way you are has to be tested very carefully to see whether you can really confidently say, this was the proportionate way of achieving our objective. We couldn't have achieved it in another way that didn't affect people in this age group more. For example, and this may be a difficult one for employers to deal with, more testing or stringent following of the COVID secure guidelines. What is it that makes those things not proportionate and can justify you going further and saying we want everybody to be vaccinated? The human rights issues we've touched on, there's a potential challenge there in terms of impinging on people's human rights. We have a case called Vavrika in the Czech Republic, which was a European Court of Justice case, where it was held that compulsory vaccination of children with penalties for non-compliance, essentially being that the children couldn't attend preschool, was not a violation of human rights. And they looked at Article 8, respect for private life. They looked at Article 9, freedom of thought, conscience and religion. But I think the key point to bear in mind, and the health warning, excuse the expression in this context for that case, is that it was a case that was set within the context of very clearly established viruses, a health backdrop of viruses that are well known, scientifically studied, where the effects of vaccination, the positive effects on herd immunity, so managing the risk of transmission, were very clearly established, and that the policy was seen as proportionate by the European courts because the fines were not excessive, and although it was exclusion from preschool, that which is an important opportunity, that was as far as it went. The opportunity to be in full schooling was not affected. So you can see how fact sensitive it is, and it doesn't amount to a strong basis or case that allows us to take a very bullish approach to the human rights question. We talked about negative press if you're a test case on this, and even if you don't breach the contract in requiring a vaccination, even the manner in which you go about communicating an expectation of it could clearly give rise to people saying trust and confidence has been broken down irretrievably, and resigning and potentially claiming constructive dismissal. So lots of issues, which is why I don't think we will have seen many at the moment employers who are putting a very firm, bullish vaccination requirement policy in place. Health and safety, I won't spend too long because Abigail's touched on this already, but you have a duty, of course, don't you, to provide a safe working environment. There's health and safety executive-backed statutory duties to assess risks in the workplace. And that means if you're wishing to impose a mandatory vaccination requirement or a conditional condition of employment that requires vaccination, you've got to undertake a detailed risk assessment, excuse me, to evidence why vaccination is required, what are the risks you're seeking to mitigate, and you're going to need to be able to do that and show that it's required in addition, as we said, to the COVID secure measures, which should already be in place as well, and consult with workplace representatives or trade unions. So you're going to have consultation duties there to the extent that you're looking at this as a health and safety issue, which I think the vast majority of people will inevitably be doing. So that's health and safety. The alternatives, as we've seen, this is a key issue in terms of your confidence you can have in justifying requiring a vaccination or requiring testing. As we've said, we're talking about testing here. Similar sorts of issues apply to the question of, can I require my staff to be tested on, say, a weekly basis? Can I say that that's a requirement and they can't attend work and be paid and make a living if they don't? Well, in both contexts, the issue of, are there alternative means of achieving your aim, for example, health and safety protection, that are less harsh on the individual? I think what you can take away from this session is that my expectation is that vaccinations and requiring somebody to be vaccinated is much more of an imposition, and therefore the level to which you might need to go to show there aren't other alternatives that could be used may be a higher burden than with testing. But what are those alternatives? Well, you might think of just encouraging vaccination take-up. That may work very well. You may get a large degree of people taking up the vaccine sufficient to manage your risk or make you comfortable with it. Think of the winter flu program. You might introduce your policy on vaccination around that. Consult with staff and get them to buy into the policy. That may make them more comfortable with engaging in the idea. And your communication strategy should be thinking about that. How are you going to communicate and when? What about the COVID secure measures? Are they fully up to speed? Have you reviewed them? And are they doing as much as they can do such that you have those in place and still feel there are risks to your workforce that mean you feel you would potentially be able to justify requiring something more like mandatory testing or employment conditional testing, or indeed even more high level vaccination? And maybe you'd look at that and go, we think vaccination will be difficult for us to confidently justify as a requirement, whether that's for human rights or discrimination grounds. But maybe testing is something we feel more confident with. Well, maybe that's the alternative. We're going to do regular testing and health and safety reviews. But even then, think about when and how you're going to require employees to test themselves and why. Will you pay them? If they're going to have to sit in your car park and be tested for half an hour, will you pay them for that? Is that working time? And in any of these contexts, you may be looking at the segmented approach. Should you be approaching your employment population, your staff population, in a segmented way? Maybe there's a grouping of staff who, for example, have a particular exposure to vulnerable adults or the elderly. And so your approach to the policy around testing or vaccination for them is going to be stricter than for those who have no real interaction with others during their work. I mean, if you took working from home, for example, query what your level, how you could justify in the same way requiring testing or vaccination for those. So segmentation is something to think about as well in the alternatives. Disciplinary and dismissal then, this is relevant to both vaccination and testing situations, of course. If you're thinking about how you deal with someone who is refusing to engage in your requirements. So you say, well, continued employment's conditional on you being vaccinated or tested. If they've got service, i.e. 2 years or more, and you've gone through a process of issuing warnings and you've got to the end of the road on that, well, if you terminate, then they'll have a basis to challenge that as an unfair dismissal, of course. And that's going to raise issues. Is it a reasonable, underlying reasonable management instruction to require someone to be vaccinated and say that's conditional, your employment can't continue beyond X date unless you've done it? That's going to be highly fact sensitive around issues like what are the reasons why you feel vaccination is required for that particular individual. Think of those issues we just touched on about segmentation. What's the risk profile for them? Why in their particular case do you say it's a reasonable request? And what are their reasons for saying no? Your risk may be very heavily influenced by that. If there's someone who is just apparently being difficult, has no particular concerns, quite happy to be vaccinated, but just says, I'm not interested and don't want to do what you tell me to do, I'm just being difficult, where your risk profile is lower, not removed, there's still a risk if you dismiss, is lower than someone who has clinical reasons why they can't be vaccinated, where your risk is going to be very, very significant, may even feed into disability discrimination. So risk assessments are still going to be key, aren't they? In the backdrop to any disciplinary or dismissal procedure, clear risk assessment. This is the risk we're trying to deal with here. It's a risk that applies to you in this way, and these are the steps we've taken to encourage you to comply. We come to alternatives again in a similar but slightly different way as we looked at with human rights and discrimination, in that if you're looking at dismissal, obviously a question is going to be, is that a reasonable response to the situation? Would a reasonable employer have dismissed? Is that within the range of actions? And you can look at alternatives. The tribunal they'll look and say, could you have done something, or should you only have gone to a slightly lesser degree of here? Should it have been a final written warning and a further opportunity for the person to comply? And we need to think about that as well. What are your other reasonable means? So it's possible, but we're going to have to go through those careful analysis if we're going to be looking at disciplinary and dismissal action. And data protection, just very quickly, there's online materials and guidance on this. So if you're looking at this area, that will be very useful, specifically dealing with the issue around vaccinations and testing. This issue of immunisation status is clearly a health issue. It goes to the person's own health status. So it's special category data. You've got to have a lawful basis to process it. You've got to have a condition for process that falls within Article 9. So as Abigail said earlier, it could be employee consent, but bear in mind, they can remove that at any time. And if they do, you've just lost your basis to process the data. And essentially that means you have to stop. Or is it your legitimate business interest? Again, that might link into health and safety, or it might not be purely health and safety. It might be about the ability for the individual to go to certain places and do certain things like traveling internationally, which has a link to health and safety, but is more directly your own business expectations. And Article 9 conditions, well, are you relying on the fact that you're performing a right or obligation in connection with your employment, or maybe health purposes? But if it's the latter, specific health purposes, a bit like occupational health, you'd be looking at needing information and confirmation from the health provider as to how they're going to use the information, etc., and giving that to the individual. You need a clear and compelling reason for recording the information is the key message from ICO. And data retention, I think this is a particularly interesting issue on vaccination and immunisation status, because the basis for arguing retention may reduce over time. For example, if by the end of this year, the vast majority of the adult population are vaccinated, can you really justify retaining that data on your staff when you may be able to be very confident in assuming that almost all of them are vaccinated? And privacy notice, from a practical perspective, if you're going to change your processing in this area, do your privacy notices to staff, make clear that that's one of the things that you will do with their data. So issues there in terms of the process to work through. And finally, implementing a vaccination program, think about staff consultations. How are you going to communicate it? Do you get buy-in by involving staff? Think about those data protection issues we just talked about. Can you use the policy to reduce risk of workplace conflict. These are sensitive issues about should I get vaccinated, should you not, is testing appropriate. You may find conflict arises. Maybe your policy can help to try and get in front of that. Think about how and when you're going to review the policy. When private vaccination becomes available, or when all adults are able to get a vaccination, which is definitely not the case now. And think about the purpose and benefits of your proposed approach. That's key, isn't it? Why are we trying to impose this approach? What are our reasons behind it? And that will give you an indication of how strong and confident you can be in justifying the requirement to have people partake in testing or vaccination. So lots to think about. I'm going to go back to Abigail now, who's going to talk about the thorny issue of refusals to return to the workplace. So back over to you, Abigail.
Thanks, Adam. So what I wanted to do in this short section was to tie in some of the discussion points today into a short scenario. So the scenario I've put together, so you're currently in the process of putting in place a COVID secure working environment. You've elected your health and safety representatives with whom you're consulting, and you've sent communications out to employees to say that you'd like people to return to the office on the 22nd of July after the planned lifting of the remaining government restrictions. But there are a small number of employees who are saying to you that they don't want to return to work. So let's look at this. So first one, an employee says it's causing them anxiety and they would rather just work from home. So let's look at that one first. I would say, looking at that, what aspect of the return to the office are they anxious about? You've clearly given them information, you're sending communications out. Do they need more information? Some individuals will need a little bit more comfort around returning to work for all of the reasons that I spoke about in the first section. It may be that they have childcare issues, or they might just generally have a bit of social anxiety, and that's just exacerbated in the last 14 months. Do they need a phased return to manage? Sometimes a blunt instrument of you're working from home up to the 21st of July and then you're back in the office will cause people some concern. They don't know how they're going to manage it. They're worrying about what their commute's going to be like, and various things. So for those sorts of people, would increasing by a couple of days each week and bringing them back up to full time, if that's what you need, be appropriate? If it's very serious and there are some real concerns there that they just won't come back to work and they're feeling very anxious and that's just what they're saying, well, I think it's appropriate to go and get some occupational health input there in terms of whether there's anything underlying and whether you as an employer need to do anything to help with that. If there's a possibility that there is a disability there in terms of an underlying condition, well, then you will need to look at whether there are any reasonable adjustments that you can make to them, whether that is working from home or some other flexibility, and whether a return to the office is justified. So what is your legitimate aim there in having people back to the office? Now, it may be because you need that, their role needs to be based in the office. It's been working okay at home for a year, but it's not ideal. There are productivity issues, collaboration issues that you can evidence and say, actually, we do have a legitimate aim to have people back into the workplace, at least, if not full-time, part-time. And then is that return for that individual proportionate in achieving that aim, if there's an underlying disability? But I certainly think in terms of managing that from an initial perspective, it sounds like they need a little bit more information, perhaps coming in on their own before the 22nd, so they can see the workplace and sort of understand how it's laid out, what their desk would look like, for example. The second employee in your scenario says they've got no childcare in place, so they don't want to return to work. Now, the lead-in time for this is important in terms of people making arrangements. That change anxiety I spoke about they've, in one breath had to sort out children not being at school, potentially if their childcare nurseries being closed, to now saying, right, you've got to get them back into their childcare or different childcare providers, and there may not be as much capacity as there was pre-pandemic. So that's why the lead-in time that you're doing this scenario, planning and saying it's going to be in a couple of months' time, is helpful, because it then gives employees a chance to plan that return to work. If they can't find anything in terms of childcare, is it appropriate to look at additional unpaid leave or some holiday? Time off for dependents probably isn't quite what you need at this point, because that's very short term by its nature, but it may be that you can have a combination of paid leave or potentially unpaid leave for them to resolve some issues. Do note, in terms of legal considerations, the potential for indirect discrimination if that employee is a female, because they are still deemed to have the predominant childcare responsibilities. But ultimately, you're not paying people to look after their children whilst they're working. The pandemic has turned that on its head a little bit in terms of childcare settings closing, but moving forward, as we get back to a little bit of normality, employees are going to have to make some arrangements, and if you, as I said before in the other scenario, if you have a legitimate aim in terms of bringing people back into the workplace for your business, then there are ways to work around that. And finally, an employee who says that they don't want to come back because they don't want to work in close proximity with other colleagues because they are worried about catching COVID-19. And that links us back to those section 44, section 100 issues in terms of detriment or just dismissal for raising a health and safety concern, and whether there are circumstances of danger and how reasonable that belief is from that employee. And that's going to involve looking at the nature and the level of your risk assessment, the communications that you've made to the individual, what that individual's circumstances are. So are they, an otherwise fit and healthy 32-year-old, or are they someone in their mid-60s with an underlying health condition that perhaps, as Adam pointed to earlier, hasn't been able to have the vaccine for whatever reason. Now that person's concerns might be a lot more genuine and reasonable than someone who perhaps has been vaccinated, isn't in one of the high risk groups. If you have all of your risk assessments, your communications, your COVID secure plans in place, transmission levels are low, vaccine uptake is high, and it's reasonable to get those individuals back into the workplace, then it may be possible in this situation to look at any process for potentially dismissal if they continue to, or disciplinary if they continue to refuse. But you're going to have to be very clear in terms of all of the bits before that, in terms of communicating with them, understanding their issues and trying to resolve it without going to that extreme. That's really a last resort once you've explored all other options. So that's just a very short scenario in terms of looking at some of the practical issues that we've faced. I am conscious of the time and we're at 11 o'clock. We've had a couple of questions come through. I might just do one on the vaccination, because we've had lots on the vaccinations, Adam, if that's okay. Can you differentiate between new starters and existing employees? So can you mandate new starters to have a vaccine but not your existing staff?
Well, theoretically, yes. You may say that actually there's an imperative to do that if your existing staff have just decided to take up the vaccine very fully themselves, because they may be concerned about unvaccinated people coming into the organisation. Quickly though, I think that the main legal difference will be those individuals won't have service, so there won't be unfair dismissal risks around requiring it for new joiners, but you're still going to have to think about those human rights, discrimination, other potential challenges which could arise. So the answer is potentially yes, but got to exercise caution and be very clear on our reasoning.
Yeah, Thanks, Adam. Yeah, really important. I know we've had a lot of other questions. What we will do is we will pull those together and circulate that after the event. So for now, thank you so much for taking time out of your morning. Thanks to Chloe and the rest of the Badenoch and Clark team, and hopefully we will see you very soon.